All right, court call case, People versus Sean Carlson.
Just plug Senator John, if you leave on behalf of Mr. Carlson, for my right.
Today is the date set for a couple of cost companies. We have reached a plea agreement. And
this case starts quietly, but don't be fooled. What you're about to see is a plea deal that almost collapses in real time. We're talking about a child abuse charge, a defendant trying to minimize what happened, and a judge who's listening very closely to every word. Plea agreements are supposed to simplify cases, but when facts don't line up, they do the opposite. Watch carefully, because this defendant's own mouth is about to put the entire deal at risk, and the judge is not in the mood for half-truths today.
Punishable by up to 1 year, up to 5 years probation. And upon a successful plea to that charge, count one would be dismissed. There is no other agreement.
That is correct, Your Honor. I'll think it.
John Matthew Carlson.
Has he signed any advice or rights form, counsel?
Not to my knowledge, Your Honor. I can have him sign one right now.
An attorney without a pen.
Your Honor, that has been a frequent occurrence for me, unfortunately. Thank you.
You know, that's why they made pockets. You can solve that.
It's absolutely true.
Damn. Have the defendant sworn, please.
Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. State your name.
Sean Matthew Carlson.
Sir, it is this court's understanding that you're going to plead guilty to the charge of child abuse 4th degree. That is a misdemeanor punishable by up to 1 year incarceration and up to 5 years probation. Is there a maximum fine on that? Mr. Reiser.
I don't believe so. 1 year or probation for up to
5 years, no maximum.
1 year
All right.
jail or probation up to 5 years, no monetary.
Gotcha. All right, you understand that, sir?
Yes, sir.
All right. And you also understand that pleading guilty in this case, that I would not be your sentencing judge and you would be sentenced before Judge Perry in the 15th District Court.
Yes, Your Honor.
All right, understanding all of that, do you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You had signed an advice of rights form today, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
You'll see it on the podium. Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No, Your Honor.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you're guilty of this offense?
Yes, Your Honor.
February 20th, 2024, at the location of 3137 Homestead Commons, Apartment 5, Ann Arbor City, Washtenaw County, State of Michigan. Did you have care or custody of a minor child?
Yes, Your Honor.
And what did you do with reference to that child?
I hit him in the arm with a closed fist.
All right. How old was the child?
10 years old at the time.
All right. And in doing so, you were doing something in excess of discipline?
This is the moment everything hinges on. The defendant admits hitting the child, but notice the wording, in the arm. That detail is not accidental. In criminal court, where a child is struck matters enormously. Arm versus face can mean the difference between sentencing severity, future custody issues, and even civil liability. This is a classic attempt to narrow responsibility while still accepting a plea. But courts don't operate on selective memory. Police reports, injuries, and medical observations don't bend to narrative control. Ask yourself this. If the facts were harmless, why does the story keep shrinking?
Yes, Your Honor.
And that did, you would admit, cause physical harm to that child?
Yes, Your Honor.
I'm sorry, I didn't hear the initial factual basis for the plea.
Which part?
What did he say he did to the child?
He said he hit the child with a closed fist in the arm.
Okay, so if I could just read and make sure that this is correct for the record, the police report, Sean approached the minor child and punched him with a closed fist in his face, causing his head to snap against the wall. Is that correct, sir? Did that happen?
That's not what happened.
Okay, there's a big difference between the arm and the face.
Yes, Your Honor, I do believe it's a sufficient factual basis, however.
Here's where the courtroom energy changes instantly. The police report says punched in the face, visible injury, bleeding, and suddenly we've got two completely incompatible versions of reality. Judges cannot accept a guilty plea unless there's a solid factual basis. And right now, that foundation is cracking. This isn't a small inconsistency. It's credibility on trial. Watch how fast the judge pauses proceedings and sends counsel back to talk. That's the court saying, fix this, or this deal dies right here. Drop a comment. Do you think this was confusion or a calculated
on the
downplay?
line?
Was his nose bleeding when the police arrived, sir?
No,
Your Honor, would the court accept a no contest plea?
I don't know if the deal was contingent upon him pleading guilty, but obviously we have two very, very different versions of what happened. I mean, either the child got hit in the face or the arm, and either the child was bleeding or he wasn't. Do this. Why don't I pass the matter? Counsel, why don't you talk to your client?
Yes, Your Honor.
And then I'll call you guys back up and let's see what we can do.
Thank you, Your Honor.
Thank you. And then recall the case, People versus Sean Carlson.
Ian Weiser again on behalf of the people, yeah.
Assistant Public Defender Davy Lieb on behalf of Mr. Carlson, who stands to my right. Mr. Carlson, can you state your name, sir?
Sean Matthew Carlson.
Thank you for the court's patience, Your Honor. I have had additional discussions with Mr. Carlson as well as a conversation with the prosecutor. At this time, Mr. Carlson would like to enter a no contest plea.
Do I have? Oh,
I don't have an objection to that, Your Honor, and I have marked the police report as People's Exhibit 1, Ann Arbor Police Department, 24-7818, and marked the injury to the child and the relationship and the statement from the report. And ask that be admitted on the basis of.
any objection, counsel, to the court reviewing this report?
No objection, Your Honor.
That being 24-7818 of the Ann Arbor Police Department. Sir, you and the understanding is you wish to plead no contest?
Yes, Your Honor.
The basis for the no contest plea, counsel?
Lack of memory as well as potential civil liability.
All right. You understand that all the rights that I explained to you apply to a no contest plea?
Yes, Your Honor.
And everything is exactly the same. It's just that you are pleading no contest to the charge. You understand that?
Yes, Your Honor.
So to that charge, how do you plead?
No contest.
Based upon review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of the defense. Counsel, have I complied with the court?
Yes, the people are saying.
Defense is likewise satisfied, Your Honor.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court. Sentencing in this matter will be
August 30th at 9:30 before Judge Terry.
August 30th, 2004, 9:30 before Judge Perry.
Your Honor, you could just check on the form that it was a no contest plea, and the one other additional part that I believe was discussed between parties is there will not be a delayed or a deferred.
Is that correct?
That was discussed, Your Honor.
Well, was it agreed to?
In terms of my discussion with Ms. Willenbring, I believe I just asked if she would be offering one. I don't know that we necessarily agreed that we would not be seeking one. However, that may have been a discussion with the previous attorney.
What?
That may have been a discussion with the previous attorney on the case.
So it's like just maybe a miscommunication. No, we're not offering one means that the reduction happens and we're not offering it and he's not seeking it.
And that is correct.
So that is correct.
Yes, Your Honor.
He's not going to be seeking it delayed or deferred.
That is correct.
You understand that, sir?
Yes, sir.
Thank you.
He's not around this child currently, is he? I mean, probably the worst thing is he told me something. I'm looking at the police report. He's telling me he hit him in the arm. There's a clear injury to his face. And
I know that CPS is involved. I would like to think that they remained involved, although I don't know that for certain.
He did complete a reunification process through CPS, Your Honor.
And so what's the status currently?
The child is residing with Mr. Carlson. Under the guidance of Child Protective Services.
What's that mean?
He completed a reunification process. My understanding is that they maintain some involvement.
Okay, so what is that involvement?
Just recently, my CPS social worker just closed the case out just early July. Since then, I've also been going through a lot of parenting classes, and I'm going through some other things through affiliates of with protective services, with like orchards and other.
Are you taking parenting classes now?
I completed mine. It was a 10-week course.
Pardon?
It was a 10-week course.
And so you're doing, there is nothing, the child is just with you.
Yes. And protective services thought it was still okay for him to be with me.
And I've got some serious concerns with a man that can't realize that he didn't hit a child in the arm, but hit him in the face, and coming before a court and telling me that.
This case is a powerful reminder of how close things can come to spiraling out of control in court. The defendant avoided trial, but only after shifting from a guilty plea to no contest, a move often used when facts are too damaging or civil liability looms. The judge accepted the plea, but not without issuing a clear warning about credibility, accountability, and child safety. The bigger takeaway? In court, minimizing facts doesn't protect you. It exposes you. Judges don't just hear words.
In
they compare
court,
them
the
against
truth
evidence.
isn't just what you say, it's what the evidence proves. And today, that gap almost cost him everything.
So you're lucky to be leaving today.
Fair enough.
You may leave.
Thank you.
Thank you.